So here what I have is, and this is Epic Times, an Epic Times article. I'm going to get into what's going to happen on January 6th. It's titled Power of Vice President to Count or Reject Electoral Votes Disputed. It is by Peter Schwab. It was written December 29th, 2020. So it states, at 1 p.m. local time on January 6th, members of Congress will gather in the chamber of the House of Representatives to observe the formal certification of Electoral College votes for President of the United States. While it's usually a formality, nothing has been usual so far about this year's election and numerous allegations of voter fraud in key swing states. The situation is complicated by a lack of clarity on the legal and constitutional guardrails for the process. The joint session of Congress may well result in gridlock in which a clear winner of the race isn't announced at all. So like I said, we're going to have I'm trying to make this as clear as possible and explain it the best I can. We're going to have two chambers of Congress. You're going to have the House of Representatives, the Senate. They're both going to meet to count the electors. The electors are supposed to be, it's the power of the vice president, or the president of, they call it the president of the Senate, who is our vice president. So it's going to go on to explain this part. Based on current election results, former Vice President Joe Biden has received 306 electoral votes to Trump's 232 votes. Meanwhile, Republicans in 7 states where Biden claimed victory have sent their own sets of electoral votes to Washington, and some members of the House have indicated that they will object to Biden electors in some states. Any objection would require support from one House member and one senator to be considered, and at least one senator has left open the possibility he would join the effort. So that is Josh Hawley at this time. Now it's a list of, I think at this point it's 11 senators. So you're going to need an objector from the House of Representatives and an objector from the Senate. Now, this is each individual state when they go to count, when Vice President Pence goes to open up the electors. Now, the way this goes is if you have a state, let's say your state has, like New Jersey has 15 electoral votes. Depending on who wins that state, so New Jersey isn't really heavily disputed since apparently it's so blue. I don't actually know how blue it really is. Who knows if there is some sort of corruption in the system? I have no clue. Maybe it's super blue. Maybe it isn't that blue. I don't know. But New Jersey's not one that is being disputed right now. So the state legislature, they get the votes. They tally them up. They say, okay, the majority was to Biden in this state. So they choose 15 electors, all Democrats, because it's a Democrat that was elected. Now, there's 15 for the Democrat and 15 in the case of a Republican, and if it was a Republican, they would choose the Republican electors to go to Capitol Hill and cast their votes. So what we have now is we have state legislatures that, because of the voter fraud allegations and the inconsistencies, they have voted to send two. They've sent the Democrat and the Republican electors. So now when this happens, of these two sets of electors, they have to be, the state legislature is going to have to vote on which one is the legitimate one. Or the federal government legislature. So the Congress, the House of Representatives, and the Senate are going to have to vote on which one is the legitimate one. But the House of Reps, according to the 12th Amendment, the House of Reps to vote, they have to follow whatever the state legislatures say in the United States. So it's a very complicated, there are some kind of gray areas, but I'll try to explain it the best I can. I'm just trying to give you a brief overview. Now, the Constitution simply states that electors of each state have to make a list of their votes, which they shall sign and certify, and send those to the President of the Senate, who is Mike Pence, the Vice President. The President of, and this is directly from the Constitution, the President of Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. And that's the 12th Amendment there. So the Electoral Count Act of 1887, currently known as 3 U.S. Code Section 15, establishes a procedure for how the votes are counted, how to raise objections, and how to resolve disputes. First, it says that the Vice President indeed presides over the proceedings. Then it says the House and Senate leaders each designate 2 tellers. The VP opens the envelopes with the vote certificates and hands them to the tellers for counting. The tellers then read them out loud, count them, and hand them back to the VP to announce the results. So really, VP just hands it to one of these tellers. Tellers writes it down, and then they yell it aloud. They count them, and then they give it to the VP, and then he announces the results. Then, in rather convoluted language, the law says that Congress members can object. At least one objection from each chamber is needed to trigger a separate vote by both House and Senate on the objections. If both chambers agree, the objected voters are rejected. That's virtually out of the question given the Democrats' majority in the House. So what you're going to have is apparently the House of Representatives and the Senate, if there's objections on each chamber, then you're going to have the House of Representatives vote that's a Democrat elector. It's going to be a Democrat electors, but then also the Senate's going to do the same thing. They're going to vote for the Republican because they have a small Republican majority in the Senate. So because of that, it's going to offset each other. Now, then it goes on. If two sets of electors are presented for counting, the House and Senate need to separately vote on which set is legitimate and which should be rejected. If each chamber votes differently, the set certified by the state's governor should count. That would hand the victory to Biden. Now, the problem here is that the governor shouldn't matter because the person sent the government, the branch of government that is responsible for certifying and sending the electors their ballots or what have you out to Capitol Hill, out to Washington, is the legislator of the state. So it doesn't really, it's constitutionally void. I mean, this act is really unconstitutional because the legislatures are the ones that are responsible, the state legislators are the ones responsible for choosing and verifying the electors. So the state governor really should have no say because he's of the executive power. This is a legislative discretion. And that's really where the problem arises. So then it continues. The problem is there's a voluminous body of legal analysis arguing that the Electoral Count Act is unconstitutional. Congress has no business granting itself the authority to decide which slate of electors is the correct one and which votes should be rejected, nor does Congress have the power to designate state governors as the final arbiters. A lineup of legislators and legal scholars have argued, which they're right, because those are supposed to be certified. Once again, in the Constitution, and this is like the electors clause of the Constitution, the electors are supposed to be chosen and verified by the state legislatures, individual state legislatures. So it doesn't make sense that now this is suddenly a federal power where really it should get kicked back to the state. That's how constitutionally, that's how it should work. If the Supreme Court had some sort of intestinal fortitude, maybe they would actually do something. I don't know what they're going to end up doing. So I'm just trying to give you the background information, and this is what's going to play out on January 6th. Now, some jurists say it's the VP who has the sole discretion to decide which votes to count. The argument is that the framers intended for the VP to be the sole authority over the counting of the votes because the unanimous resolution attached to the Constitution said that the Senate should appoint its president for the sole purpose of receiving, opening, and counting the votes for president. Moreover, before the adoption of the Electoral Count Act, it was always the VP counting the votes. Sometimes, despite major objections from Congress, Thomas Jefferson did so as the VP in the 1800 election, counting Georgia's constitutionally deficient votes and de facto securing his own presidency. I'm not really sure about all the information pertaining to that. See, some jurists, meaning practicers of law, think that it is the VP's sole discretion to count the ballots and verify every single one of them. And I personally, that doesn't make any sense because then you're giving the sole power all to one individual who is the VP, and then that's a system that can easily be corrupted. So I don't know really who came up with that, what jurist believes that. I just don't think that's true. That does not really line up with any type of constitutional practice. That is not the electors clause. So Now, Arizona state lawmakers and GOP electors, together with Rep. Louis Gohmert, a Republican from Texas, have filed a federal suit asking for the court to clarify the law to the effect that the Electoral Count Act is unconstitutional and the VP's power is paramount. Now, this is something that he was I think he was essentially, Gohmert was like suing Mike Pence to try to get the Supreme Court to rule on something, and the Supreme Court, obviously, of course, they wouldn't even take the case. They threw it out once again because God forbid the Supreme Court actually has to make a ruling on some sort of constitutional provision, because they're not going to do right now. They do not want to take anything, and I just don't know how this is going to end up playing out if we have a bunch of lackluster, spineless people that are in our government that just are deciding to not do their jobs. And it is highly important. I don't understand why everyone is just somehow okay. I guess maybe because the media is suppressing everything that's going on, and you only have a few people that actually know about the Electors Clause or know about the 12th Amendment, but they're afraid right now to make any type of move. So, University of Virginia professor John Harrison, an expert on constitutional history, says that the VP doesn't have any constitutional power to make decisions over which votes to count, which I would agree with him on that note. Now, he argued that the law is deficient to the effect that Congress doesn't have the power to make the announcement of its decisions regarding the vote count conclusive. But that doesn't mean it can't prescribe any rules at all. The Constitution does call for counting the votes with both houses present, so I think that setting up procedures for a count is within Congress's power. Now, the second argument, and this is the one that I think is much more constitutional, and if the Supreme Court actually took the case and they followed by the Constitution, this is what would end up happening. The second argument is that the Constitution grants the authority to determine how electors are picked to state legislatures. As such, any disputes over which votes should be counted should be resolved by the state legislatures. The problem is state legislatures aren't in session, and they can't assemble in a special session without a call from the governors, who have refused to do so. So that's also something that is in the federal Constitution. I think has something like the president can adjourn the court if the court doesn't want to meet or something like that. He can like force them out right now. And I think the state legislatures, maybe because of some sort of code restriction, they're out of session and they can't meet, and the governors aren't going to make any move on it because God forbid we had some sort of people that had like a spine and wanted to figure out how to make the system work. So meanwhile, the legislatures have usually delegated the power to certify electors to the governors and secretaries of state, undermining their own authority on the matter. So that's something that is directly unconstitutional. They can't delegate their own powers, because then now you have a commingling of powers. If the legislature, for example, in the federal government, if they decided to give the power of declaring war to the president, then the president can just declare war at will whenever he wants to. It's a violation of the Constitution. So the fact that they were even certifying the electors, giving this power to the governors, and especially the Secretary of State, because a lot of these states, Secretary of State is just a bureaucrat. That's not even someone that's elected in some of these states, I'm pretty sure. Now, the Conservative Amistad Project of the Thomas More Society has filed a federal lawsuit arguing that the power of the legislatures is both exclusive and non-delegable, meaning you can't delegate it to people. You can't just dodge or obviate your powers and your responsibilities and pass it on to somebody else. And I've explained this before. The government officials love the bureaucracy. They love putting people in charge so they don't have to take any type of blame or any responsibility when something goes wrong. And thus, any state and federal statutes to the contrary are unconstitutional and void, which I think, my personal view here, from what I know about constitutional law, what I know about what I've read, this would be the best opinion. This would make the most sense constitutionally. That would not only knock down some provisions of the Electoral Count Act, but also render electoral votes that haven't been certified post-election by state legislatures illegitimate. So what we're looking at, just to try to attempt to wrap everything up for you, we're going to have on January 6th, we're going to have both of the chambers of Congress. They're going to meet. We're going to have Vice President Pence open to certify. We're going to get objectors from both sides of the Congress. And then at that point, we really do not know what's going to happen. It could either be kicked back to the state legislatures, because we're going to have the House of Representatives, because of the Electoral Vote Act, we're going to have the House of Representatives as well as the Senate are both, and this is somehow, this contradicts the 12th Amendment. That's why it doesn't really make any sense. And that's why it is unconstitutional. So that's what I'm saying. It could go where the state legislatures have to like automatically vote on it, which would be much more of the 12th Amendment. That would be much more constitutional. Or it could go the Electoral Count Act, where you have you have the House of Reps, they vote Democrat, and then you have the Republicans, they vote Republican. And this is saying all that ends up happening. Who knows? The Republicans can be total hack, spineless losers like Mitt Romney, because Mitt Romney's obviously not going to vote Republican because he's a hack job. So who knows what could happen? You can have a bunch of people that have no spine in this. Now, what could end up happening is it gets kicked back to the state legislatures, and the state legislatures then have to figure it out, or the Supreme Court has to at some point get involved, because they do not even understand how to interpret the rules. And then at some point, I think, I'm not sure, but from what I've understood, I think Pelosi can attempt to like block it or something by just saying we're not going to hold a vote, or I don't know. So then I have the next article I have here, and I'm hoping that I try to do my best to explain it to everybody, just so you kind of have the wherewithal when you go into it, and anybody asks you any questions, you kind of have an understanding of what exactly might happen on January 6th.